Good afternoon. Oh, yeah, it's working. Good afternoon, ladies and gents. My name is Martin Benedicto. I'm a Chartered Financial Planner at Close Brothers Asset Management. I'm here today with a few of my colleagues. Hopefully you've had a chance to speak to us out on the stand. If you haven't, then please feel free to come by at some point before the end of the day and have a chat with us about what we do and see if there's something that we can do for you. In terms of, make sure I choke into that. In terms of what I'm going to talk to you about today, I'm going to talk to you about our executor education. Can everyone hear me? I just checked. Yeah? Okay, good. I'm going to talk to you about our executor education program, which is a new initiative that we developed for existing clients and for new clients as well. I'm not going to be able to go into all of it. It normally runs to over an hour, and we usually have a solicitor in tow to boot. So in the 19 and a half minutes I've got left, I'm just going to give you a flavour of the sort of things that we do in it, why we do it, and a little bit about us as well. So first of all, Close Brothers, who are we? Why are we talking to you about this? Well, Close Brothers originally started out as a merchant bank, founded in 1878. We started by funding the building of railways in Alaska and the like. We still have a very strong banking division. We're a FTSE 250 company overall. And we have a strong balance sheet and a good pedigree as a merchant bank. But alongside that within the group, we've got a securities division, and more importantly for today, we've got Close Brothers Asset Management, which is where myself and my colleagues are from. Within asset management, we currently manage about £12 billion of client money, so it's private client money, money for trusts, money for charities and the like. And we also provide financial planning services to clients up and down the country. There are around 100 or so people that do my role, working with clients one-to-one. And we look to cover the whole spectrum of financial planning. So we do inheritance tax mitigation and retirement planning and investments onshore and offshore, mortgages, you name it, we pretty much get involved in it. So why have we decided to do this executor education program? Well, the bottom line is we're always looking to add value to our client proposition, and we deal with lots of clients all the time who have had either issues as executors or concerns about appointing executors. And so we looked at it and thought, well, perhaps there's something we can do to add a bit of value and to make people feel a bit better about these sorts of issues. We did quite a lot of research. We spoke to our existing clients, and we also did quite a lot of desk-based research to see what was what with it. But I guess one thing I'd like to ask, actually, just starting out, is all those that are executors or appointed executors in someone's will, could they raise their hand? Okay, so we've got quite a few here. Okay, thank you very much. Interestingly enough, only 1 in 5 people who, 1 in 5 people who are appointed executors don't know about it. So if there was like 20 people in the room that raised their hands, we've got another 5 or 6 people in here that are executors and they don't even know about it. So that's something to bear in mind. So even if you're not appointed an executor, you might get something out of today, hopefully. The key things that we sort of picked up when we looked at our desk-based research were that people found it a very stressful process. If you've ever been through it yourself, I'm sure you will echo that. In my years as an advisor, I've come across clients that have taken years, literally, to get through probate and everything else, and it's been a nightmare for them. I have had occasions where it's gone really easily, but they are the exception in my experience. 27% of all executors and this is a co-op legal services survey from last year, 27% of executors found the role stressful, 20% found it upsetting, and 7% had to take time off work. Obviously, if we can add a bit of value and avoid some of those things, that's only a good thing. One other thing I didn't mention before, to all those that just raised their hands, how many of you are aware that as an executor, you have an unlimited personal liability if you get things wrong? Well, quite a few, not everyone. Not as many hands went up that time. If you only take one thing away from today, that's the thing to take away. As an executor, the buck stops with you. If it goes wrong, you can be found liable. So just bear that in mind. And I've got a little example in a second that is quite interesting. Only 38% of people in England and Wales have a will. Obviously, if you get appointed as a legal representative and there's no will, you're on the back foot to begin with. So it's quite important that people are promoting that and making sure that they've got their affairs in order. And as I said, 1 in 5 don't know that they've been appointed. So these are comments from some of our existing clients. the usual things change frequently. I don't know what my son's going to do. I don't know if he's going to be able to cope in this situation. What can I do to make life easier for him? And that's ideally what you want to hear. A couple of articles that we came across during our research. I'll draw your attention to the Telegraph on this. Quite an interesting story, this, talking about unlimited liability. This refers to an executor who paid out on an estate before paying the inheritance tax, which is a big no-no. And the reason he did that is because the brother of the deceased promised that he would pay the tax before he went home back to Barbados. Funny enough, he didn't. He disappeared. He went back to Barbados, was never heard from again, and the executor couldn't get hold of him. HMRC took the executor to court, and the court found in HMRC's favour, so the executor ended up with a bill of £340,000 of inheritance tax as a result of their error. So that's an example. That's why you need to take it seriously, I'd say. If you're going to be an executor, make sure you take it seriously. So some of the things that we cover off on the programme, the idea really is to put people who are executors and also our clients who are appointing their executors. I think quite a common scenario is we've got clients who want their son or their daughter who's their executor to come along to this programme to feel that they're more informed, they're more prepared, they're more able to deal with the situation. And one of the things that we start with is, well, have you got your house in order? When you're doing your will as a testator and you're appointing executors, if you haven't got your house in order, then it's quite difficult for your executors to be able to deal with it. So making sure that your will's up to date, things that they should consider. Have you communicated your intentions to your executor? Really, really, really important. If you don't talk to the executors, then how are they going to know what they're dealing with? And then have you prepared an assets and liability schedule? Now, this is something that we've started to look at through another service, another initiative that we have developed called a Wealth Legacy Service, which is designed to help people sort of have solid records of their affairs. Number of times I've come across clients that are sort of searching through drawers, looking through piles and piles of paperwork, don't know where the bank accounts are held or what the insurance policy numbers are. It can be a nightmare at a time when it's difficult enough as it is. So these are important questions that we would ask a testator to consider before we start worrying about the executor and what they should be doing. In terms of the executor's concerns, well, obvious things. What do I do? When do I need to do it? What costs are involved? These are all things that we address in the programme to try and put people in an informed position. What are the risks to the family? I think that the thing to remember here is that when people are acting as executors, although they're following the wishes of the deceased, they're acting on behalf of the beneficiaries of the will. And there's a sense of responsibility there. If I get this wrong, the family may be worse off. If I don't do this in a timely manner, this may be a more difficult process for the family. So in this instance, it's really important that as an executor, you put yourself in the best possible position to do everything that you can. What does it mean to me personally as an executor? Well, the bottom line is it's a big commitment in time and energy, and as we've already said, there's potential for unlimited liability if you get it wrong. And then how can I ensure I'm best prepared? Well, talk to your testator for sure, and stay in touch with them and be totally au fait with their affairs, and perhaps attend something like this to give yourself a bit of an idea of what you'll be needed to do. As a role of executor, being an executor, some of the things that we look at, the roles, responsibilities, the duties, the process of applying for probate. Most people can do this by themselves, and a lot of people will do. Where people start to ask for additional help usually is where we're talking about calculation and settling of taxes. A lot of people will be a bit unsettled by having that responsibility, and that's where I would say most people will then start to look at additional help if they don't want to hand the whole thing over to a solicitor at the beginning. Legal obligations and liabilities, and then potential pitfalls, do's and don'ts. Again, things that we would cover off as part of the programme. The role of the executor and sort of the stages that are involved in being an executor is another thing that we cover off, because that's quite a key part of the programme. Accepting executorship, don't have to. You can turn it down, don't have to do it, you're not forced to. But I'd like to think that if you'd agreed to do it during someone's life, that you would follow through. But it's still a choice. collecting and collating all testator assets goes without saying. Your responsibility is to distribute those assets and pay the taxes. You've got to collect them up first. Paying the expenses and liabilities, including your own reasonable expenses, is acting executor. Calculating and paying IHT, as I said, that's one area where we tend to find that people need a bit more help, potentially. Distributing remaining proceeds to beneficiaries once you've paid the tax, as we said before. And then communication. It's really important that during the life of the testator you stay up to speed on their situation, what assets and liabilities they've got, and what you're expected to do with them. So when we look at another area, we look at potential errors, pitfalls, do's and don'ts and the like, liabilities for executors. Potential errors, incorrect taxes calculated, I think that's one of the more common ones. Late payment of taxes, that can lead to additional costs. Distributing assets to the wrong beneficiary. I like to think that's not very common, but I'm sure it does happen at some point. Failure to identify a creditor. That's another big one to bear in mind. Creditors have got 6 years to claim against the estate. If you miss a creditor, they can knock on your door 2 years later and ask for their money. And then delegating a decision to relating to the estate to someone with no legal authority. You're expected to get the help that you need to fulfil your duty, but at the end of the day, as I said, the buck stops with you as the executor. And we've already said unlimited personal liability. So as I've already mentioned, claims for creditors, 6 years. They've got up to 6 years to make a claim. Beneficiaries have got 12 years. So it's really important that you do a thorough job and make sure that you're in a solid, informed position before you start actually acting as executor. And that's where good communication with the testator during their lifetime and ongoing communication with them is going to pay dividends. And then, yes, executor liability insurance. It does exist. Like most things in life, there's always at least one insurance company out there that's willing to cover a risk for the right price, and executor liability insurance is no exception to that. So things to avoid as an executor. Well, I think the key thing really is there will be certain things that you won't be able to avoid. If you are acting for a testator that has a villa in the south of France, you can't ask them to sell their villa in the south of France before they die because it's going to make your job easier to administer their estate afterwards. So some things you won't be able to avoid, but what you can avoid is being in a position where you're not informed about everything that's there and how to deal with that. So if you are acting for an executor, a testator that has a villa in the south of France, make sure you know about it, make sure you know what their wishes are, and get their insight into what should happen to that and what laws might apply. Perhaps do a bit of research at the time as to what you might have to deal with, because that's likely to take longer than dealing with property here. It's going to be a little bit more complicated. So the more prepared you are for that, the easier it will be, and that's something to avoid. Is not being prepared. But along with those sorts of things that you should avoid is estimating timescales. Don't tell a beneficiary that you're going to wrap all this up in 6 months, and they don't have to worry about paying their mortgage off that they're worried about or anything like that, because you're going to have the money to them soon. The number of times I've come across clients that have taken a significant amount of time to deal with things, or as I say, done things quite quickly. You've got to make sure that you don't misinform them in estimating timescales. Conflicts of interest, being a beneficiary and an executor, no problem with that. Very common, in fact. But obviously, if you're a beneficiary, don't use your position as executor. Push yourself to the top of the queue. Make sure there's no conflict of interest there. I've stopped moving. Oh, no, there I am. Complexity of business assets. Again, if there are business assets in the background, something you need to be aware of, something you need to deal with when the time comes. Assets abroad, foreign jurisdictions, premature settlement of bequests. We've already said don't pay anything on until it's time to, and make sure that all the taxes are settled first. Contested wills. Can you avoid a contested will as an executor? Well, not really. But what you can do is have a really good grasp and understanding of an individual circumstances that you're acting for executor with, at what the will says and what the potential issues might be. I would like to think that if there is the potential for the will to be contested, the individual testator might have some idea of where the issues may be, and perhaps those can be addressed in their lifetime, rather than left for the executor to try and deal with after the death of the individual. Occupied property, again, it's an awareness piece. You can't kick tenants out the door on the day that someone dies because you need to sell the property, but you need to know where you stand and sort of what the situation is there. DIY, doing it yourself, yes, okay, you can do it all yourself, but if you need a bit of help, make sure you get it. And then not being well informed of testator affairs underpins everything. If you're not informed, then you will struggle in many ways potentially. Additional considerations for testators and executors. Power of attorney. Often you will find that someone acting as attorney for an individual will also be their executor. That's quite common, but not always. If that's the case, then really you do want your attorney and your executor on the same page. You do want, if the power of attorney becomes relevant in the individual's lifetime, you do want them to be pulling in the same direction and not contradicting what the wishes of the individual are, and making sure that the attorney is not doing something during the lifetime which contradicts something that was expected from the executor when administering the estate. Costs and how they can be reduced. Yes, it's an expensive business. Death is an expensive business. The tax man likes to take as much as he can at that point. Tax is obviously the biggest cost in that situation. There are things you can do about it, but it needs to be looked at well in advance. Hard costs of intestacy. Yeah, if you don't have a will, you can make things harder. Not only would you make things harder for anyone that might represent you or distribute the assets from your estate after your passing, but also there's a potential to trigger an inheritance tax liability that could have been avoided. So not having a will is a big no-no really in any sort of estate planning. And then use of websites, age concern, government websites for inheritance tax, those sorts of things are quite useful things that we would point people in the direction of as part of the programme towards the end. So estate planning overall, what is estate planning? This is sort of my final roundup. I mean, it says here, to ensure the right people inherit your wealth as per your wishes and to minimise the amount lost to inheritance tax. Minimising tax is the first thing that comes to mind when people are looking at estate planning, but it's not just that, it's also about making sure that your affairs are in order, as we've already sort of touched on, and that your executors are in an informed position and able to fulfil their role as efficiently as possible. And that's why we are running these sorts of programs. That's why we are developing this other service, as I said, called a wealth legacy service. It's all about joining all those things up alongside the tax planning that we already do for clients. And hopefully that's given you a little flavour of what's involved in the programme. If you'd like to talk to anyone about either getting involved, coming along to one of the sessions, or a bit more about other things that we do, please do grab one of my colleagues or myself over at the stand before the end of the day. But hopefully that's given you a little flavour, although it was a whistle-stop tour. Well, thank you very much for your time.